everyone. So welcome to join our second our second privacy event webinar today on the topic of future-proofing your marketing in the age of privacy. So this event is co-organized by EdTech and Programmatic and Measurement Committees. We are honored to have EternityX to be today's event sponsor, and EternityX is a cross-border marketing technology company that focuses its business on bridging the gap between international brands and the China market. Now, may I invite the lead of our EdTech and Programmatic team, Sally, to give us an opening remark and introduce today's speaker. Thank you, Sally.
Thank you, Alvina. Hi, everyone. Thank you so much for spending time to attend the event that is co-organized by the EdTech and Programmatic team and measurement team this year. There are several guests from demand side, for the supply side, and also from the demand side, both from a publisher and also brands, and to provide some most updated information and solution to us today. So please expect that today will be a very fruitful section. We are very pleased to have Mr. Kevin Duan to join our section to talk about what are the things that the marketers should watch out for, especially when there's a China data privacy law. The new Personal Information Protection Law, PIPL, imposed last November. It is China's first comprehensive law designed to regulate online data and protect personal information. For any brands and advertisers that are engaged in marketing in China, there will be like a lot of uncertainties in the marketing, and we are honored to have invited a special guest from Beijing, Mr. Kevin Duan, a leading lawyer in China, to focus on data privacy. Today, he is going to share insights on the latest development as to data privacy law in China and what is the impact on the cross-border marketing activities. Kevin, please feel free to share the information with the audience here.
Thank you, Sally. Thanks for having me. And I will take this opportunity to introduce to you a bit what is taking place here in China in terms of the data privacy law and what are the potential implications to those, in the marketing industry elsewhere around the world. So as you probably have heard that, data laws in China has changed a lot since about 2 years ago. And last year is actually a critical year in which we see key legislations, including the Personal Information Protection Law, PIPL, as well as the Data Security Law. Both are pillar laws in the data domain. And for today, I think I'm going to be focused on the personal information related part, which is the PIPL. So, yeah. So the PIPL really, if you look at the language, the terms of the PIPL, as you'll see clearly, it's really a counterpart of GDPR. In many ways, you will see it's imprinted by the GDPR. That doesn't mean that the PIPL is not a law, a PRC law with certain features that it may see in other PRC laws. But we're going to introduce that part a bit later in this speech. With respect to the PIPL, I think it came into force last November. And with that, surrounding the effectiveness of the PIPL, you do see a set of ancillary regulations and national standards came into force. It is kind of interesting because, all those kind of laws and legislations in China are rather abstract and vague and hard to implement in real-day life. So that's why we need this kind of regulations and standards just to put more, more flesh on that to make it more practicable to those who are really subject to the laws. With respect to that, we are referring to regulations, including the measures for the security assessment of the outbound data, and also this security assessment part is actually going to be, we're going to see the final draft of that in a week or two, for which it really sets out the conditions and the procedures that you will have to go through when you try to export data from China. So that's going to be a very critical one. And the other is the regulations of the Administration of Network Data Security, which is really a more detailed implementation guidelines or rules for the PIPL. So those are two very important regulations. As well as important is the algorithm recommendation administrative provisions, which sets apart the things that may be relevant to marketers, because for all those like recommended personalized ad that we're gonna see or gonna push for the data subjects or users using apps, those are probably subject to the algorithm recommendations. And then we also have those kind of national standards, industry standards, for which I don't want to get too much details of that, but just to let you know, even if those national standards and industry standards are not mandatory, they are actually quite important in real-day enforcement. All those regulators will refer to the national standards, voluntary national standards, looking for details when they actually working on their cases, simply for the reason the laws are too abstract, so they cannot really have something to rely on, while the national standards does have a lot more details for which you can actually refer to. So also relevant is that surrounding the effectiveness of the PIPL, you see many lots of enforcement cases. For that, we are referring to enforcement cases on apps. Specifically, there's a case against an app operator collecting personal information, including MAC address, IMEI, Android ID, all those kind of identifiers, without users' consent to the privacy policy in the first operation. And for that, so this is something that marketers might be interested in, because in certain operations in China, at least prior to the PIPL, we know there are operations that may not be strictly following this rule to have the consent first or proper notification first before collecting anything like any identifiers, including MAC address. And also there are other kind of judicial cases for SMS, pushing, all those kind of stuff. Just another example of how the enforcement is gonna actually using PIPL as kind of the enforcement basis. So this part is actually a framework and summary of what PIPL really looks like, for which the details I will get into that later. But as you may see from here, the PIPL actually in the very beginning of the PIPL, it discussed about the application scope of that. So in addition to the mainland China, it also includes, it has the extraterritorial application power like the GDPR. So if you are sort of targeting data subjects living in mainland China, or you are monitoring their sort of behaviors, you will be subject to the PIPL, even if you are not a PRC company. And also the scope of the PI is quite broad, a counterpart to that under the GDPR. So really, it's not only like identified personal information, but also something that could be that is identifiable or actually generated by certain data subjects that would be counted as a personal information. And that does has a very so sort of like the impact on the business and all those who are handling the personal data in China. For cross-border data transfer, as I mentioned earlier, there's going to be implementation rules, or sort of like what you need to do in terms of security assessment before being able to the cross-border data transfer. And for that, I will get into that part later. On the data subject rights, does provide a comprehensive set of data subject rights from which you can see under both the, for those under the GDPR and the CCPA, CPRA, all those kind of data subject rights, you will see those in China. Just even more comprehensive set of that. The problem with the data subject right is that despite the establishment of the data subject rights under the PIPL, because the law is still relatively new, and as I mentioned, it's so abstract, so many of the standard, like the implementation level, is still unclear to those who are subject to the laws. So it does need more clarification from the regulators and also more enforcement cases for us to be more clear what we need to comply in terms of the data subject rights. And also interesting is the legal liability. For those who don't know, PIPO is actually very strict. It follows the GDPR scheme. So in the worst case scenario, you will be subject to a fine up to 50 million RMB or 5% of your last year revenue, which is a lot. So that's basically the framework and summary of that. So the application scope, for which we'll get into that, is I think those who are attending this meeting might be interested in what is the extraterritorial effects of the PIPL. It's actually very similar to the GDPR. So in the case that you are uploading those apps in the Chinese app stores, or you are using the RMB as the settlement currency, or you're shipping goods to China, targeting data subjects in China, you will be subject to the PIPL. So unlike to those pre-PIPL era, well, those companies outside of China don't really have to worry about the data loss in China. The PIPL for the first time sets a very clear rule that they are working or they will apply to this even outside of China. And the scope of personal information, as I mentioned, is just very broad. And in case that you're interested in all those like MAC address or these IP address, they are likely to be considered as personal information. And anonymization standard under the PIPL is actually very vague. So for those those information, despite you're doing all those kind of de-identification processes or efforts, if it still has the personal or individual granularity, it might still be counted as the personal information. So that does set a sort of barriers for those who would like to circumvent their PIPL by doing the de-identification work. So those are the things that you might want to know as the marketers. On the second point is regarding the CN users. So it's always important, as every data law you will see around the world, consent is the preferable legal basis in the marketing scenario. And in that case, if you are applying the consent basis, of course, you will have the right to withdraw the consent. So in marketing, I think it's one of the utmost choices for many, because there's just simply no way for us to rely on the fulfillment or the of the contracts, those kind of legal basis. And also notifying user of PI processing activities is actually very actively enforced in China. So meaning if you are a third party obtaining, shared by these data handlers, certain kind of data, personal data, you will probably be disclosed in the privacy policy of the party who are collecting the data. And the PRC regulators are actually very strict on this, meaning they are requiring or aggressively looking at privacy policies and asking them to list all those third party who will be shared with the personal information. So SDK developers, and also probably those who use the personal information for those in the marketing industry as well, will need to be disclosed in the privacy policy. And also equally important as for the identifiers, as I listed here, you will see in some recommended national standards, it clearly says that the unchangeable unique device identifiers, such as IMEI, MAC address, etc., cannot be used for pushing information and profiling users. Simply saying they are not, they are discouraging people or person or companies from collecting this kind of identifiers, like the permanent identifiers. So this is not really mandatory under the PIPL, but rather under those kind of voluntary national standards. Just the trend that the regulators are looking at this, and there might be some stricter enforcement cases in that regard. So need to be careful about that if you're still doing this as your business. And also important is about if you're doing their personal advertising, personalized advertising or targeting advertising, the law does require sort of the opt-out option for those who are watching the advertisement. So if you are displaying information in a personalized way or pushing marketing with information to individuals, you will always have to provide this kind of turn off option or rejection option. Interesting is that the law does also provide individuals the rights to choose or delete their labels. this has not been actively enforced by the regulators by far, because there's still a lot of arguments on whether this is necessary and to what extent people will need to comply with the law by providing this kind of options. But it's just a possibility. If that's the sort of like de facto standard someday in the future, I think it's going to have a huge impact on the marketers. Also, is that the big data discriminatory pricing? I think that's more for the operators, on the operators or the publishers, and that's meaning if you are using the tax or to labels to provide a certain price, there's no reason that you can simply like increase the price because it just looks more, they're more rich or things like more sort of fitting for the purpose. So those are the requirements. Also about the business partners. So before getting into that part, I think I will introduce about the roles of players under the PIPL. It's a bit different from the GDPR. So there's the entity or term called PI handlers, which really mirrors, or to a large extent is identical to the definition of personal data controller under the GDPR. And there's another term called interested party. To a large extent, it also can be considered as personal data processors under the GDPR. So those kind of the PI handlers and interested parties, so those roles of companies that are collecting their personal data or processing the personal data are actually very important because they do have different sort of obligations or responsibilities. So if you are a PI handler and you are entrusting a certain party to process the data, so it is your obligation to supervise the entrusted party to comply with the PIPL. So in the case that the entrusted party does sort of have the liability or breaching the rules by doing things that is sort of out of the scope, and you might be held jointly liable if you did not do your due diligence or impact assessment before engaging this entrusted party. And on the entrusted party's end, so you cannot process beyond the agreed purposes of data processing activities, and you cannot subcontract without consent of the PI handler. Also, you will need to return the personal information to handler or delete it after termination of the agreement, the processing agreement. So with that being introduced, so let's look at the cooperation between the PI handlers, meaning you are equal parties rather than sort of like the being entrusted relationship. So for a joint PI handler, so you're meaning so Article 20 says there's a joint PI handler, meaning you do have this kind of both decides on what kind of data to collect and what the kind of processing activities of this kind of data might be. So you're considered as joint PI handlers. For separate PI handlers and data, if you're sharing this data with another PI handler, so you will need to inform the name and contact information of the recipient, and you will need to have a separate consent from the data subject before being able to do that. That means, in application scenarios, you will have to disclose in the SDK list or PI sharing list the third party who's going to receive this kind of data, and also need to set up a separate option or checkbox for this kind of data share. Third-party data vendor and also other kind of third parties who's going to be touching hands on the personal data being collected by those by the PI handlers, because the law does set a joint liability for those who are sort of like being counted in the chain of processing in the processing of the personal data. So you have to be careful before engaging or sharing any third party or this kind of processes, because their fault or breach of the laws might be counted as your liability if you don't do your due diligence or the impact assessment before doing anything that is with them. So those is the important takeaway, is that you will have to do this kind of impact assessment, And you have to set the obligations very clearly in your engagement or, sort of like the agreement with them whenever you try to engage data vendor or engage interested party for your data processing. For the cross-border data transfer, for those who are interested in that, from cross-border data transfer from mainland to China to Hong Kong will be counted as a cross-border data transfer. So in that case, you will have to do a self-assessment for risk before any kind of cross-border data transfer. And you have to have a separate consent. And also you will have to enter into a SEC sort of like agreement for this kind of cross-border data transfer. And also important is the CAC security assessment. If you are triggering a certain triggering condition, meaning if you are transferring a large amount of personal data, or you are important personal data handler and you're trying to export this kind of personal information, this transfer, cross-border data transfer, will have to go through the CAC central level security assessment before you're being able to do so. And that implementation rules is going to be set out in the measures that's going to be issued in a week or two from now. So that is very important. I don't have much time, so I'll jump on key points just in case you're interested. Also about marketing is that for internal policy and management, if you are subject to the PIPO because of the extraterritorial application, you will have to be careful to working on the internal data governance, meaning you will have to set up a representative in mainland China according to the PIPL. Also, you will have to set up a PDO in terms if you are possessed a certain amount of personal information, say more than 1 million. And also you will have to do the personal information protection impact assessment whenever you are processing sensitive personal data, doing cross-border data transfer, or sharing this personal data with a third party. So those are all the things you need to do. Legal liability, as I mentioned, is very severe. I don't want to get to the money part. Just as interesting is that it does have a personal liability. And in addition to monetary liabilities, there are things like built into your social credit system. Meaning, if you are a person in charge of the business and the business actually violates the law, you might be held liable. So meaning you cannot, be working on the executive level or working in charge of the data protection business, things like that. And data subject rights, as I mentioned, is very comprehensive set. Anything you see in the GDPR and CCP is already there. Recommended responses. So in light of what we have just talked about, so it's very important. I think 4 things you need to be aware of is the cross-border data transfer. So this is going to be a real thing you need to work because the rule is going to be issued very soon. And so for those who are, sort of having this personal data transferred outside of China, we all need to work on this part. Data sharing and trusted sharing processing, you have watch very carefully for the third party, being it a data vendor or an interested party, otherwise you will be held jointly liable. And also you will have to improve your privacy policy and internal regulations in light of the new laws, including PIPL. Otherwise they might be outdated, and you will be held liable for that kind of thing. And also the potential risks is that you need to really evaluate the enforcement cases to see if there's anything relevant to your business, because the law is really abstract. A lot of the standards need to refer to the enforcement cases. So if there's anything relevant, consult with your outside counsel, understand what the real risk is and what you can do to mitigate the risks. So for that, I will conclude my introductions and I will leave the part later for the Q&A session. Thank you.